So if you're doing any kind of business globally or even just thinking about selling a digital product, data privacy is, well, it's the new frontier.
It really is.
And today, we're doing a deep dive into what is, it's arguably the most consequential regulatory launch since GDPR, India's Digital Personal Data Protection Act of 2023, the DPDPA.
It's a huge milestone. We're talking about the world's largest, fastest growing digital consumer base. And the notification of the DPDPA rules of 2025 means this landmark law is now fully operational.
Complete with mandatory deadlines.
Exactly. And this framework is set to fundamentally reshape how every company, domestic or foreign, handles the data of Indian residents.
That magnitude is.
Yeah.
That's exactly why we're here. This act, it didn't just pop up overnight.
Not at all. It's the end result of 7 years of drafting, negotiation. It all springs directly from the Supreme Court's 2017 KS Puttaswamy judgment.
The one that officially recognized privacy as a fundamental right under the Indian Constitution.
That's the one. What's immediately striking, though, is the declared philosophy behind it. The law is designed to be SERL, simple, accessible, rational, and actionable. Now, the implications are anything but simple, but the legislative goal was clarity. It uses remarkably plain language compared to, its global counterparts.
Okay, so our mission today is to cut through all the noise of those new rules and deadlines. We need to find the absolute accountability this framework imposes on businesses, what they call data fiduciaries.
Right.
And really pin down how this Indian model fundamentally diverges from giants like the GDPR. We need the so what for international founders.
To get straight to that so what, let's quickly clarify the roles. They generally map to what you already know. You have the data principal, that's the individual.
Okay.
The data fiduciary is the entity that determines the purpose and means of processing. So essentially a controller.
And the data processor is the vendor.
Exactly. The vendor who processes data on the fiduciary's behalf.
Yeah.
And critically, this law has extraterritorial reach, meaning if you are a foreign company offering goods or services to Indian residents, the DPDPA applies to you, regardless of where your servers are located.
That's a huge point right there. Okay, so let's move into our first crucial segment. The immediate headline for any compliance overhaul seems to be, consent is king.
Absolutely. You can only process data for a lawful purpose, and the main way to do that is with the data principal's consent.
Or what's the other option?
Or you have to fit into one of the very narrow, legitimate uses that are listed in Section 7.
And this is where I think international compliance officers really need to stop and rebuild their whole strategy.
This is the moment, yes. If we connect this to the bigger picture of global compliance, the DPDPA, it does not recognize legitimate interest as a ground for processing personal data at all.
Wow. Okay, that's a structural earthquake for global operations. Most big companies, especially those running complex analytics, they rely heavily on legitimate interest for a lot of their processing in Europe.
For internal analytics, fraud detection, general ops, you name it.
So if they can't use that basis in India, how do they have to rebuild operationally?
They face a binary choice. They either have to secure consent or they have to fit into one of those narrowly defined legitimate uses.
So give me an example. What about, say, an automated fraud detection system that analyzes user behavior?
That's a perfect example. Under GDPR, you might argue legitimate interest because it's necessary for business health and the user isn't overly impacted. Under DPDPA, that argument just fails.
So what do you do?
You either have to get specific verifiable consent for that fraud system, or you redesign it to only rely on data that's necessary for a legitimate use like preventing losses, which is a much, much narrower scope than a general LI analysis.
So if consent is the primary driver, the bar for that consent must be pretty high. What defines valid consent under the DPDPA?
It is extremely demanding. The consent must be free, specific, informed, and unambiguous, requiring a clear affirmative action.
And there's one more word, right?
Yes. It must also be unconditional, meaning you can't condition the provision of a service on the user's consent to process data you don't actually need for that service.
But the word that really leaps off the page to me is verifiable. That seems to push the challenge from the legal department straight into the engineering department.
You've hit the nail on the head. That's where the rubber meets the road.
What does verifiable actually mean in practice?
Well, verifiable suggests that just ticking a box and saving a timestamp isn't going to be enough. Fiduciaries have to implement robust, auditable technological mechanisms.
Like consent dashboards and immutable logs.
Exactly. Things that clearly demonstrate when consent was given, what purposes were consented to, and that the user can review and withdraw that consent at any time. It's closer to a cryptographic proof of action than just simple record keeping.
Given that complexity, let's quickly touch on those narrow exceptions, the legitimate uses.
Right.
Where can companies operate without explicit consent?
They're very restricted. The exemptions really focus on necessities, complying with legal obligations or court orders, medical emergencies, epidemics, disaster management, that kind of thing.
What about when a user just gives you their data?
That's covered. The voluntary provision of data for a specified purpose, say, you enter your phone number just to get a confirmation SMS, that's a legitimate use.
Okay, and what about employment data? That's a huge sensitive category for any large company.
Right. And fortunately, there are some very clear, sensible carve-outs for employment purposes. It's estimated to cover about 80 to 90% of a company's typical employee data processing.
So things like payroll, managing leave.
Payroll, managing leave, issuing ID cards, security, loss prevention, all that is generally covered. But, and this is an important but, if you want to use an employee's data for something else, say their photo for an external marketing campaign,
Then that's outside the exemption.
and you need explicit consent, absolutely.
Okay, let's turn to the phrase that should be giving every CEO a bit of a pause. Absolute accountability. This is our second segment, focusing on this breathtaking liability structure.
It is breathtaking. The law imposes absolute non-delegable responsibility on the data fiduciary under Section 8.1.
That phrase, absolute non-delegable, it sounds like the most important legal innovation in the whole act.
I'd argue it is. It means two things that fundamentally alter the risk model compared to GDPR. Think of it like a parent hiring a babysitter.
Okay.
The parent, who is the data fiduciary, is still 100% liable for the child, the data, even if the babysitter or the data processor violates the contract or is negligent.
So the fiduciary is on the hook, entirely responsible for compliance, irrespective of any contract they have with the processor. They pay the fine, then they have to sue for damages later.
Precisely. And the second major alteration, liability stands even if the data principal fails to carry out their own duties.
Wait, so there's no contributory negligence defense?
None. If a security failure occurs, the company can't argue, well, the user gave us false information or the user clicked on a phishing link. The fiduciary's duties are 100% intact.
And the core duty there is.
The core duty under Section 8.5 is to implement reasonable security safeguards. Security is non-negotiable and non-derogable.
And when we talk about a security failure, the consequences are pretty stark. GDPR fines are proportional, but DPDPA has these high fixed penalty amounts. What kind of damage are we talking about?
The penalties are designed to sting. Failure to maintain reasonable security safeguards can result in a fine of up to 250 crore.
Which is about 30 million US dollars.
Roughly. And failure to notify the Data Protection Board or affected individuals of a data breach, that runs up to 200 crore. These aren't percentages of revenue. They're fixed ceilings designed for maximum deterrent effect.
Let's go back to that chain of liability. If a fiduciary hires a processor and that processor subcontracts to a third party, does that absolute liability extend all the way down the chain?
It absolutely does. The law creates this chain liability. The data fiduciary is fully liable for any processing done on its behalf by any data processor or sub-processor.
Which puts an immense burden on due diligence and auditing every single link in your supply chain.
A massive burden.
What are some of the other non-security duties that fiduciaries have to maintain day to day?
Well, they must strictly adhere to data minimization and purpose limitation. They also have to ensure the completeness, accuracy, and consistency of data.
But only in certain situations.
Yes, specifically if that data is going to be used to make an automated decision that affects the data principal or if it's disclosed to another fiduciary.
And when is the data processing relationship considered over? What happens then?
That's where mandatory erasure kicks in. The fiduciary has to erase the personal data as soon as the purpose for which it was collected is no longer served or when consent is withdrawn, whichever is earlier.
And they have to make sure their processors do it too.
Yes, they have to actively cause their data processor to erase the data. This requires demonstrable destruction protocols, not just, marking records as inactive.
We've spent a lot of time on what the company must do. Let's flip the lens now to the individual, the data principle, and look at the powerful tools this framework gives them.
Sure, they get comprehensive rights. The right to access a summary of their data, the right to correction, updating, or erasure, and the right to grievance redressal.
And crucially, the right to revoke consent at any time.
Easily and simply, yes.
But there's one really unique feature here: the right to nominate. This feels very specific to legacy planning in the digital age.
It's a profound and totally unique provision. The data principal can nominate another individual to step into their shoes and exercise their rights under the DPDPA in the event of their death or incapacity.
And how is incapacity defined?
The law defines it quite broadly: unsoundness of mind or infirmity of body.
That seems like a major technical and legal workflow burden for companies, doesn't it? It's more than just a checkbox.
Oh, absolutely. This isn't just a legal right. It demands a new, complex technical workflow. Fiduciaries need processes for nomination registration, secure verification of the nominee, and, most challenging, a legally defensible protocol for verifying the principal's death or incapacity before activating the nominee's rights.
That's a huge engineering and compliance lift. Now, before an individual can escalate an issue to the government, what do they have to do first?
The data fiduciary has to establish an effective internal grievance redressal mechanism. The data principal must use and exhaust this internal mechanism first.
And the fiduciary has to respond within a certain time frame.
Yes, they're required to respond to all grievances within 90 days. Only after that can the principal approach the Data Protection Board of India. It really pushes responsibility back onto the company to solve problems first.
So let's talk about that ultimate adjudicator, the DPBI. What is the Data Protection Board of India's role?
The DPPI is designed to be a centralized, digital-first adjudicatory body. So, it acts like a specialized digital court for data protection. It investigates breaches, issues binding orders, and, of course, imposes those huge financial penalties.
When the DPBI imposes a penalty, where does that money, that 250 crore fine, for instance, actually go? Do the affected users see any of it?
This is a critical distinction. The penalties are payable only to the government. There is no mechanism within the DPDPA for the DPBI to grant financial compensation or damages directly to affected individuals.
So it's purely punitive, not compensatory. That's a huge philosophical difference from the EU model.
It is. It feeds right into the core comparative challenges.
Okay, so let's quickly summarize the three big differences for international founders who were juggling DPDPA and GDPR.
First, the legal basis. DPDPA's strict reliance on specific verifiable consent means that legitimate interest loophole is completely closed.
Okay, one, what's two?
Second, breach reporting. DPDPA requires reporting all breaches to the board and affected individuals.
For those who don't know GDPR inside and out, can you explain why ditching the high-risk threshold test is such a big deal?
Sure. Under GDPR, you only have to report a breach if it presents a high risk to the rights and freedoms of natural persons. This lets companies triage minor incidents internally.
But DPDPA is stricter.
Much stricter. There is no risk threshold. If it's a breach, you report it. That's going to significantly increase the volume of incidents and the level of regulatory scrutiny.
And the third difference, cross-border transfers.
This is actually where DPDPA is more flexible. It uses a liberal blacklist approach. Data transfers are permitted everywhere to all countries unless the government specifically blacklists a country.
Which is much simpler than GDPR's complex system of adequacy decisions and standard contractual clauses.
Far simpler operationally.
Finally, we have to talk about AI. AI runs on data, often for purposes that aren't defined yet. Is the DPDPA seen as AI-friendly? Or is that a specific consent rule a major blocker?
It's both, which creates this constant tension. It's seen as somewhat AI-friendly because you might be able to use slightly broader purpose drafting in your notices, like for future model training.
But that's limited by the specific and verifiable consent requirement.
Severely limited. If you collect data for purpose A, and later you want to train a high-stakes AI decision model for purpose B, you need new consent.
And the accuracy requirement for automated decisions must also restrict some of these high-speed probabilistic AI models.
Absolutely. The requirement for completeness, accuracy, and consistency applies whenever personal data is used for an automated decision that affects the individual. If your AI model gets it wrong because of bad data, the fiduciary is liable.
So that forces organizations to slow down and invest heavily in data integrity and algorithmic transparency.
Which can counteract the very speed advantage that AI is supposed to provide in the first place.
So this deep dive really shows that the DPDPA is a regulatory powerhouse. The key takeaway for you, the listener, has to be that seismic shift toward absolute non-delegable accountability.
Backed by those massive financial penalties, up to 250 crore.
Right. And this consent-first architecture fundamentally forces a policy and an engineering overhaul for any global company that is serious about the huge Indian digital market.
And that leads to a really profound question that executives have to grapple with. Given that the fiduciary's responsibility for compliance is non-delegable, extending down to its processors and sub-processors, how will global organizations effectively vet and audit their multi-tiered outsourced subcontracting chains to meet this extremely strict standard of certainty?
Especially in a market that's focused so heavily on speed and innovation.
Exactly. That mandatory audit trail suddenly becomes the most expensive piece of digital real estate you own.
A challenging thought to end on for sure. Thank you for joining us for this crucial breakdown of India's new data landscape. And, this deep dive was powered by compliance leaders like www.compliancehub.wiki and www.generatepolicy.com. They're really great resources for navigating the kinds of complex policies we talked about today.
They are.
Until next time, keep digging and keep learning.